A new president plus a new Congress equals big changes in the American workplace.
This is the American Law Journal. Made possible in part by The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
By most accounts, 2008 has been a watershed year in the realm of labor and employment law. But with new government, new laws, and a bevy of Supreme Court cases, as the saying goes, you ain't seen nothing yet. And maybe, just maybe, everything old is new again. Hello, I'm Christopher Naughton, and welcome to this special edition of the American Law Journal, where this week we are working in concert with the Legal Intelligencer. This program not only broadcasting on the Comcast network, but you can go to the Legal Intelligencer's website and you can read this discussion in its entirety. You can also go to our website, lawjournaltv.com, where once again, every program that we broadcast here later goes up to the website as a webcast. This program, airing as a half hour on Comcast, can be seen in its entirety on the website. If you need more information, call us toll free at 888-78-LAW-TV. Write to us at info@lawjournaltv.com. Go to the website and get your law on demand. Let's go ahead and meet my six panelists tonight as we look at the year in review, Labor and Employment 2008. Was it indeed a watershed year? And what's ahead? Maria Petrillo is my first guest to my left tonight. She hails from the law firm of Jackson Lewis, and she has spent the entirety of her career in the area of labor and employment. Peter Boyer joins us from McCarter and English. His areas of practice, labor and employment law, of course, and business litigation. Peter is also a regular lecturer with New Jersey's continuing legal education. Wayne Pinkstone joins us this evening. He hails from the law firm of Fisher and Phillips. His areas of practice, employment, discrimination and harassment, personnel policies, and trade secrets and unfair competition. Gary Lesneski joins us from Archer Greiner, the president of that law firm and also the chair of their labor and employment law group, as well as their healthcare group. Anthony Haller joining us once again from Blank Rome Corporate Defense. He has practiced in all areas covering all aspects of labor and employment law, including preventative counseling and, when necessary, going to court. He's got extensive background in both complex litigation, trial, and appellate work. And to keep all of our corporate counsel real honest tonight, George Kounoupis, hailing from Hahalis and Kounoupis. He will need indeed to be the super lawyer that he is tonight, because he's going up against, if you will, 5 corporate counsel. George's practice in both Pennsylvania and New Jersey, representing those who claim age, race, sex discrimination, wrongful termination, and the like. A recent survey conducted by the Association for Corporate Counsel tells us that almost 60%, actually more than 60%, of the corporate respondents say who gets elected president is going to make a difference. Now that we have President-elect Barack Obama, Anthony Haller, why should that make one bit of difference to your practice?
President Barack Obama will make a large difference, because I think it is a certainty that the Employee Free Choice Act will be passed. The Employee Free Choice Act is going to radically change the way that unions can get elected, and it will radically change what happens when a union is elected. The rules surrounding what employers can do in terms of dealing with organizing campaigns and what they can do in bargaining, and there is a proposal to have mandatory arbitration to resolve the first round of bargaining if necessary.
We are going to cover that in depth a little bit later. Gary, how is it going to impact your practice now that we have Barack Obama?
I think, adding to what Anthony has said, I think we can expect a number of initiatives if there's a Barack with President Obama that will impact traditional labor law. For example, I would expect that you'll see legislation that will attempt to prevent employers from permanently replacing striking workers. I think that you will probably see a move afoot to have more frequent increase in the minimum wage, probably annual indexing. Paid parental leave, I think, will be on the table.
Wayne Pinkstone, what about you?
I agree. I think that we're going to see an expansion of employees' rights under the various employment statutes. For one example is the FMLA. I think we're going to see an initiative to introduce a certain period of paid leave during the 12 weeks that is now certain employees are permitted under the FMLA. So I think in general we're going to see an expansion of the FMLA. I think we're going to see an expansion of the ADA when the new amendments go into effect on January 1st, 2009.
And Pete, it sounds like, again, expansion of benefits, if you will, for the worker, expansion of workers' rights. Do you see it any differently?
No, I think I generally agree. You know, I think the economic crisis that we're facing is going to be sort of overwhelming at first for the new administration, and I'm not sure these things are all going to take off quite as quickly as they might otherwise have happened. But I think we'll see it. And the other thing long term that I think will be very significant is the composition of the U.S. Supreme Court, I think, will change as a result of President Obama's appointment of new justices to that court during the course of his term.
Right. So if something comes up in the first couple of years, you can expect it one way or the other to impact employment cases.
Absolutely.
Although it's interesting to see where this court's been going with employment cases, which we'll cover a little bit later in this roundtable. Maria, do you see it any differently?
No, I absolutely agree with everyone, particularly the Employee Free Choice Act. It's job one for President-elect Obama. But in addition, I think there will be clear direction for federal agencies like the EEOC and others, the Department of Justice, to really focus on issues of systemic discrimination, for example, and really make employers hold the line and come to task for any problems that they have in their workplace.
Well, George, according to your colleagues, everything is coming up roses for your clients.
Well, I agree with everything they've said, and I'd like to add a few more things. I think the FMLA is going to be expanded, and I think it's going to go down from 50 to 25. I think the Ledbetter Fair Pay Act is going to be enacted. I think the Title VII ADA caps on compensatory damages are going to go, and certainly on the plaintiff side, we welcome the Free Choice Act and some of these other acts, the Respect Act, the Forewarn Act, and some of these other things. But I'm not so sure that with an Obama administration that the economy and the crisis, to the extent that it continues, is going to keep them from proceeding. They see this as a core part, the civil rights part, the non-discrimination part as a core part, together with some education type reforms that they're proposing. I don't think that they're going to see these as anti-business. Indeed, that's part of the debate. Are these anti-business in some way?
All right, let's take a look at age, race, and sex discrimination. Is it still the straw that stirs the drink? According to the Association of Corporate Counsel's latest survey, in addition, nearly 3/4 of corporate counsel surveyed said their companies faced employment-related litigation over the past 3 years, with discrimination complaints being number one. According to the survey, almost 75% of corporate counsel said their companies had been a defendant in employment-related litigation, and that they faced discrimination complaints, with wage and hour complaints being second, about 27%. As the number of discrimination complaints go, 42.4% of the respondents said that they had remained pretty much the same over the last 3 years. A little over 27% said they had gone up, and 11.1% had seen a decrease. Let me go to plaintiff's counsel first. Age, race, and sex discrimination cases. Is it a better case today than it was 10 years ago?
Is it a better case today than it was 10 years ago? It depends. It depends on the case, and it depends on the judge, and it depends on the court, and it depends on the circuit.
Right. So that's a maybe.
The law, certainly the Supreme Court has made some decisions in the past 3 years that are good, and has made some decisions that are bad. It's made some decisions such as Desert Palace, which allows us to prove causation better. It's made some decisions such as Burlington, which helps retaliation.
Right.
It's made some recent decisions on evidence involving other supervisors and allowing that evidence to come in. So in the evidentiary side, some of the courts have been generally favorable, allowing us more evidence.
Does that surprise you a little bit, given what some would call the conservative nature of the court, that these discrimination cases and we're going to get to in just a moment, the retaliation cases seem to have an open gate?
That, to the extent that my answer to you was that what I like is seeing a greater ability to prove my case.
Does defense have the same perspective, age, race, and sex discrimination cases? Wayne, your thoughts?
I still see a ton of sex, race, age discrimination cases, gender, race harassment cases. I was in before a judge out in Pittsburgh, a federal court judge out in Pittsburgh recently, and 60% of her docket was employment cases. it is still there are a huge number of employment cases that are flooding. I think it's down a bit than it was maybe 5 years ago,
Right.
but there are a lot out there.
So age, race, and sex discrimination cases, Pete, are still dominating this area of the law for you.
Yes, and it's just sort of the human condition. You put people together in the workplace, and they're human beings, and they're going to interact, and all our foibles and flaws come out. And
You would have thought we had learned something in the last 30 years.
Yeah,
I mean,
well,
all the corporate counseling you folks have been doing
we
to
try,
employers.
we try. But the other thing I think that's going on is, and again, I go back to the economic situation. I think as companies downsize, you're going to see more claims because people are not going to just happily walk out the door. They're going to start looking at what happened and why they were selected to be the one to be let go, and they're going to go to a good plaintiff's lawyer who's going to look at it very carefully. And in many cases, you'll have a claim that results from that.
Let's talk about age, race, sex, and other types of discriminations. First cousin, the retaliation case, which is ever pervasive. Wayne Pinkstone, what hath Burlington Northern wrought?
Well, what it's done is when the case first came down, it was seen as a major case, and to potentially expand retaliation claims and what it meant. I'm not so sure that's actually happened in how it's been interpreted. Since that decision has come down.
And yet the Supreme Court, I think, has revisited that issue several times. The Third Circuit, I believe, is clarifying that issue. I mean, it's hot, certainly, if nothing less. But because the courts are putting so much focus on it, one has to think that they think it's a pretty big issue.
I agree, even though I don't know what the impact has been necessarily from that case. The retaliation claim, I see it often in following the sex and the gender or race claim that I get. You will see a retaliation claim, a retaliation component alleged by the plaintiff's attorney because the allegation is that there was a complaint made about harassment or discrimination and there was an adverse employment action taken, whether it was demotion, decrease in pay, or termination. You often see it in these cases.
But Anthony, have you seen an upshot since Burlington Northern, which came down in 2006?
I have a different view from Wayne on that. I really think it's made a radical difference to the practice and the type of cases that are being brought. I agree in respect that we always got retaliation claims because the retaliation claims are the ones that, if you can prove them, bring the big money and jury awards. So they've been there, but the burden of proof is so different now. And what it's allowing is plaintiffs to make claims that before 2006, we routinely, as defense lawyers, got kicked out on summary judgment because there wasn't a specific adverse employment action that was the subject of the retaliation.
But retaliation is great because now, if I can prove notice, if I can prove causation, and most of the causation cases, if you have any evidence, proximity, are going to go to the jury. Now I'm going to get a retaliation case to the jury. And the jury never wants to believe somebody's a racist, doesn't want to believe somebody hates older people. They have to be forced. But they can believe that somebody did not want somebody running around wants to sue them. They find that easy to believe. It makes sense. It's human nature. We don't believe somebody's that evil, but we can believe somebody running around saying, you're racist, you're not treating me fair. That they want to get rid of that person. And so it's a wonderful thing for us. Burlington, of course, is a major development to our practice.
I'm from my end, it's always been true that if you have a case brought by a plaintiff, and that plaintiff continues to be employed, so it's a lack of promotion case, a demotion case, every cross-eye or turned shoulder or a cold comment becomes a retaliation claim. I've had EEOC charges where there have been 4 and 5 charges laid on top of those because of retaliation.
The U.S. Supreme Court has a case before it right now on this retaliation issue. The court has certainly taken a great interest in this area. And I think I'm sort of in the camp that agrees that it's made a pretty dramatic difference. Because what you try to do as a defense attorney is to narrow down the cases that you have to actually go to a jury on. Because you go to a jury, you're going to do your best and you're going to present your best case. But no matter how good you are, it's a little bit of the roll of the dice as to who the jury's going to ultimately believe.
I think employers countenancing these retaliation claims. And clearly, there's been an uptick, and there will be more if employers do not systematize their performance evaluation processes, engage in sound training of their managers, really take seriously their internal investigative complaint processes, and do it fairly and fully. You're just asking for it.
Let's move to the ADA Amendment Act of 2008. As I said at the outset of this program, maybe everything old is new again. I've had complaints from employee attorneys, from employer attorneys. No one, courts, no one seemed to like this Americans with Disabilities Act, at least what it seemed to have been evolving into in these last few years. Now, President Bush signs into law the ADA Amendment Act of 2008. Gary Lesneski, do we have clarity at last?
Well,
maybe, maybe not, huh?
As John Gorka says, I'm from New Jersey, and for us, this is a non-event in large measure, because
Absolutely.
in New Jersey, the focus has been on discrimination, not qualification, for a long time.
All right.
So,
And that's based on your Law Against Discrimination
yes,
Act,
and
which
so,
gives, purports or does give more protections for
yes,
injured
so
workers,
our
for
courts have
workers in
always
general.
been focusing on the discrimination element and very little on the qualification element. So, and that has been just the opposite. So, for example, our plaintiffs' attorneys in New Jersey, they're not filing ADA claims. They have been filing, they go right to file LAD claims. So for us, this is just a federal law beginning to catch up with where we've been for a long time.
Have your courts now been flooded since the opponents of the ADA restoration said that it would expand to a class that cannot be defined? Have your courts been flooded with cases upon cases?
No, because we're already flooded, George. We were flooded for the last several years, so the flood is already there and it hasn't subsided because the threshold for a discrimination claim based on handicap or disability in New Jersey is very low.
Wait.
I think that the amendment is meant to broaden the definition of what is considered a disability under the ADA. And I think it's going to have a major impact on how we defend these cases and certainly how employers react to and treat disabled employees.
If it is indeed a throwback of sorts, as some are suggesting that it is, does it make it tougher on you?
I think it makes it tougher initially on an employer and on an employment side lawyer in seeing how is it going to be interpreted, how are the courts going to react to the amendment, and what do we need to do to make sure that we comply. So yes, I think it has a major difference.
But in this area of employment, whether we're talking about discrimination, we're talking about retaliation, and now this new law passed by President Bush, it seems as though it's going to open up, give a little bit of breathing room for the workers, which will supply all of you with more work here at the panel, but should give some brighter lines when these cases do go to trial, if they do go.
It's much easier for the plaintiff's lawyer to get through the door to make the case on the discrimination point. So you put aside California and New Jersey, where these cases have been going on, everywhere else in the country, now George can get to court. And I have said many times, because it's an area I've lectured on a lot, that these cases change for a defense lawyer when you're in court. You can, in the context of discovery, take on the issue, you're not really that seriously ill or you don't have that bad a condition. But when you have them up on a witness stand in front of the jury, you don't really want to be attacking them that way. And so I think it changes the whole nature of the defense, and then you're into a very kind of different area. So our strategy has been to get rid of these cases on summary judgment, and I think that's not going to be anywhere
easy anymore.
as easy.
I've heard at least, if I've heard one attorney say this on the employer side of the ledger, I've heard probably 10, and that quote unquote old labor is coming back, and especially now with the Democratic Congress. So Anthony, I guess unions are down to about 8% in this country, which is 1/6 or 1/7 of what it probably was in the middle of the last century. Is this new, again, this new Employee Free Choice Act, is that the only way the unions are going to get a toehold again? In other words, let's have open ballots. People have to raise their hands, I suspect, in an open forum, let people know how they're voting, and this is the only way they're going to be able to herd folks together to get a union going.
I think the answer is yes. I think that you have to start by looking at this statute at a macro level. I mean, this is a political statute, and it's the purpose is to change, some people would say level the playing field with respect to how unions can get a voice in the workplace and be recognized by employers.
But there are many ways that unions can influence. One recent case was told to me by a corporate lawyer who said that they went out and after the initial vote, there was 30% something, they went out and they purchased all the groceries that the union dues would purchase in a year and put them there and said, look, this is what you're giving up. Now that, might be legal at this point, but it, under the Free Choice Act, would be deemed to be conduct which is not appropriate.
The problem with the legislation isn't just the card check, but it's also the mandatory arbitration. I mean, in this, that's right. So you have a situation where if you have this union essentially certified by the National Labor Relations Board, you are going to have, in 10 days, a party can demand basically negotiation. Then you have a window of 90 days to negotiate your first contract. It's virtually impossible to do that. And if you don't do that, then you have 30 days for mandatory mediation with the Federal Mediation and Conciliation Service. And God forbid, if you can't agree then, you're going to have an arbitrator imposing all of the terms and conditions of employment on the union and the employer. An arbitrator, who is that person? Does that person understand the business? That is the problem, really, besides the individual freedom of choice in terms of knowledge and secret ballot election.
All right, let's assume for a minute that this becomes a reality, this Employee Free Choice Act. Now what for the employer? What are they faced with?
Well, they're faced with a whole different dynamic now in terms of dealing with the union organizing. I mean, all the rules have changed. And, I agree that the card check bothers me because just philosophically, I think there's a sort of a tradition in this country that you have open debate and you decide things based on that. And I understand the arguments that the employer maybe has an advantage under the current rules, but it just takes that away. But the arbitration provision is the one that really scares me because it's such a short period of time. The union is holding all the cards because they know they can force it into arbitration by taking a hard line. And I don't think any of us know exactly where that's going to go. But from the employer's side, it looks like it's not going to go to a pretty place.
Well, the Association of Corporate Counsel also in its latest survey took a look at whether or not employers believed that there was going to be this scenario, given our soft economy, that workers would have to be cut. And here's what the results are. The workforce levels, more than half of the respondents, 52.8%, said their companies were not instituting reductions in force in any of their operations, while 47.2% said they were. Let's go around the table. Is that genuinely what you're hearing from your clients? Or let me go beyond that. Are you hearing that in labor circles in general, that we're going to see cuts? Marie, you're shaking your head.
First of all, the survey was taken back in August. I believe our firm helped or participated in that process. And so that was August. It was before the great tumult of the last series of weeks. And then literally today, I think, today's news was over 60,000, or is it 600,000? It was a huge number in the last several weeks, a huge number of people who have been laid off. And unfortunately, I think you will see more of the same.
So how does that impact your client, Peter? Beginning, I mean, obviously it's got many ramifications, but where do we start?
Well, I think the one thing you have to really focus on is you got to anticipate some of the things we talked about earlier today, about the discrimination claims and sexual harassment claims and things. You've got to think about what you're going to do and how you're going to go about it if you're going to lay people off. And you have to be very careful and systematic about how you do it. It's not a pleasant thing. And people are not just going to say, okay, I'll leave. I mean, it's your lifeblood. And so it's a very difficult thing. It has to be handled in just the right way. It can be done, but it's got to be done carefully. And I agree that I think the statistics that you quoted are old. And I think that the economic circumstances we're in are really, in my lifetime, the toughest I've seen. And I don't think anybody really knows I chuckle when I hear that we're just about to go into a recession. We've been in a recession. I mean, let's not kid ourselves.
Ladies and gentlemen, let us take a quick look back and then a quick look forward, take our crystal balls out. Has 2008 been a watershed year in the area of labor and employment? And isn't it going to be an interesting 2009? Maria, let's start with you.
Well, absolutely. I think with the amendments to the Americans with Disabilities Act, with new regulations for the Family Medical Leave Act, which clearly needed some fine-tuning, with the EEOC insisting that it was going to go full bore on systemic discrimination issues. We have all kinds of things. And then the prospect moving forward of what we've talked about, the Employee Free Choice Act, in and of itself, I think 2009 will certainly be a watershed year.
Peter Boyer.
Yeah, I agree. I think while there have been some dramatic things this year, I think next year is really the year when we're going to see very dramatic change of the landscape for all the reasons that we've talked about today. And the presidential election will have something to do with that.
Wayne, what do you think? I know you said to me that the practice of labor and employment law looks dramatically different than it did 10 years ago. Now moving forward, is it going to look dramatically different in 2009?
I think it may. I think 2008 was a watershed in terms of the introduction of things that are most likely going to occur and be implemented in 2009, which I think is going to change all of our practices vastly. So yeah, I see 2009 as a year of uncertainty and potentially a big impact.
In New Jersey, every year is a watershed year for employees. So this was no exception.
As long as there's a law against discrimination.
We now have paid family leave in New Jersey. So we have a lot of things going on. I think the federal changes have been significant. I feel that traditional labor is going to make its comeback, and I think that's going to be very important to labor lawyers in the next couple of years, first half of the next administration. Anthony.
I would describe it differently from a watershed. I was trying to think of a good analogy, and I'll come up with it, and you may not think it's that good. I feel like I'm standing on the edge of a precipice, and there's a thundering herd behind us. Because
ready
I
to
think
push the employer attorneys
well,
into the pit?
I think we're not quite sure, where it's headed. That's why I describe it that way. And I think you have to recognize that there's always a gestation period, a gap between the time these things happen and when they really start impacting, because it takes time for people to bring cases and them to flow through the system. So a lot of these things that we're talking about, like the ADA amendments, I don't think we're really going to see the effect for 1, 2, 3 years down the road. Employee Free Choice Act, if it happens, I think is going to be immediate, and then I think employers are falling off the cliff.
George, do you see the same metaphor?
I think if you take 05, 06, 07, 08, there's watershed years. I don't think 08 by itself rises to that level. What I want to see in 09, I want to see Burlington be upheld fully and Sixth Circuit decisions that are ridiculous not being upheld. I'd like to see the ADA Restoration Act, that the courts, it sinks in what that means and the regulations follow. And I'd like to see the Supreme Court say that mandatory employment law arbitration provisions are not allowable, that you can't do that. So those are 3 things would make me happy in 09.
I think what's going to make probably all of you happy that despite the fact that a number of corporations are laying people off, and I've even heard of some law firms having to change their practice and lay people off as well, I doubt many labor and employment departments, especially in the large firms and the significant plaintiffs' firms, are going to be facing that problem in 2009. And hopefully we'll be able to address some of those issues as we move into the new year. For all of us here at the American Law Journal, we want to remind you, go to our website, lawjournaltv.com, call us toll free, 888-78-LAW-TV, write to us at info@lawjournaltv.com. And if you'd like to actually read this discussion in print or online, go to the Legal Intelligencer's website. There it is, legalintelligencer.com. I'd like to thank Maria Petrillo from Jackson Lewis, Peter Boyer from McCarter English, Wayne Pinkstone from Fisher and Phillips, and Mr. Gary Lesneski from Archer Greiner, Anthony Haller, Blank Rome, and our sole plaintiff's attorney, who's obviously grown in esteem of his defense colleagues tonight because you didn't beat them up, nor did you get beat up. And that's always a good day, is it not?
Mutually beneficial relationship.
But he's the only one that got a wish list.
For all of us here at the American Law Journal and at the Legal Intelligencer, thank you for joining us. We'll see you next week.
Tonight's American Law Journal has been made possible in part by The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.